Hey, what's up, y'all? Y'all know my slogan. I don't know it all, but I know what I've been through. Now, before we get into this video, make sure you check us out on Patreon at www.patreon.com/Hookah Anonymous _. You guys been telling us to create one for the longest, so we recently created a community where we will upload videos that we can't share on YouTube due to their guidelines. We'll also be dropping the latest to there first, behind the scenes information that you wouldn't find anywhere else on our socials. So make sure you become a member, and after you do that, head over to our official Instagram page at Hookah Anonymous _ and follow us there. Now without further ado, let's get into what you guys came here to see. Now, we got new information in regards to this Lil Durk and OTF trial coming up. As y'all know, in one more month, we're supposed to be seeing the trial that we all been waiting for. And y'all know it's going to be a few things coming out before the trial actually hits, if it doesn't get delayed yet again. This time we have Durk and his attorneys accusing the feds of hiding evidence and trying to delay trial on purpose, according to them. And now Durk's attorneys are demanding that the new charges be dismissed before trial next month. Now, first off, let me tell y'all this. Demanding the feds to do anything is comical. Nobody could demand the feds to do anything, and I'm no lawyer, so Brian Steele and Drew Finland would know way more than me. However, the fact that they're complaining that the feds brought new charges late and held evidence, this is what the feds do. These are the tricks that they have up their sleeve, but not only that, I'm not sure if that will be considered evidence in this case, if it's considered new charges for a separate case. I'm not sure, y'all, to be honest, so anybody who have law experience or anything in that field, please let us know in the comments. Now, it's also being alleged that Durk's legal team is demanding a speedy trial and is asking the judge to dismiss new charges, claiming the government's actions have unfairly hurt their defense, but prosecutors disputed those claims, saying otherwise. Let me tell y'all right now, I can't see the judge dismissing the whole case where they have cooperators openly involving Lil Durk and claiming that he did play a role in it, especially when it adds up to the same thing he's being accused for in the new case. But like I said, none of us know what the outcome is going to be. We're just going to have to stay tuned and see what happens. Now we're going to get into the new documents that have recently been put out, and we want to hear what y'all think the outcome may be. Durk and his attorneys have been trying for a speedy trial for the longest, and I told y'all before, it's just a play to get the prosecutors to basically rush. But I think there's a reason the judge haven't granted them the ability to a speedy trial, and there's also a reason the prosecutors have been taking so long. As I always say, keep in mind that the suspects in the Duck case still haven't been sentenced and they have already been tried and charged. What's the holdup? I still think there's some type of correlation with that case and this OTF trial, but I could be wrong. We just gonna have to wait and see. So we're gonna get into the document, but before we do, make sure you hit that thumbs up button, hype the video so we can get into the algorithm, and if you not subscribed to the platform already, make sure you do so now. Let's get into it. Hold up, y'all. There's no way you're watching this video for free right now, where you could be getting paid literally just for playing games while this video play in the background at the same time. Only difference is the increase in your bank account. Now, I'm not saying you'll get rich, but I am saying that you could easily make something while doing nothing except for sitting on the couch playing games if you download the app Free Cash. Tap or click the link I pinned in the comment section or scan the QR code that I put right here on the screen. Also, if you use my link right now, they give you a little something to start off with just for signing up. So if you want a little Uber Eats or something to snack on and don't feel like dipping into your own wallet, play a few games so you don't have to spend your own ends. Now let's get back to the video. Now the documents will state, quote, defendant Durk Banks, through his attorneys Drew Finland, Marissa Goldberg, Brian Steele, and Christy O'Connor, hereby files this reply in support of his motion to sever counts or an alternative to dismiss on speedy trial grounds, docket number 446. Whether a purposeful dilatory tactic or lack of diligence or both, the government's actions in this case have endangered Mr. Banks' speedy trial rights. Those actions include bringing last-minute, wide-ranging charges that were equally available months ago. They include massive, belated discovery productions related to those new charges. They include the government's refusal to abide by the pretrial schedule to which it previously committed. In its opposition, the government does not and cannot provide any good explanation for why it has intentionally impeded Mr. Banks' impending trial date. Instead, it scatters a constellation of vague excuses but failed to connect the dots. What material new developments explain the third superseding delay's timing? Why is the government just now turning over volumes of discovery that it has had in its possession for months? The government is banking on a continuance, behaving as if Mr. Banks has waived his speedy trial rights and the August 20th trial date is already off calendar. Not so, its unfair dilatory acts are a transparent attempt to delay justice. But for Mr. Banks, who remains incarcerated and eager to go to trial, justice delayed is justice denied. This court shall restore the fairness the government attempts to strip from Mr. Banks and sever the Los Angeles counts for an August 20th trial. Government's actions have endangered the trial date. It is beyond dispute that the timing of the government's actions here have imperiled the August 20th trial date. The government sought a hefty superseding indictment just 11 weeks before trial. It has withheld discovery. For example, it refused to comply with Mr. Banks' October 17, 2025 request for the Chicago case file and then misrepresented to the court that it had turned it over when it had not. Large portions of the Chicago discovery, nearly 10,000 pages, were produced as recently as Monday, July 6, just a month and a half before the scheduled trial date. Another large production occurred on May 29th, but with errors that were not fixed until June 26. This is despite the fact that the government has always had access to it. Further endangering the trial date, the government shirks its responsibilities under the pre-trial schedule to which it previously agreed. For example, after extracting a promise from all defendants that they would not seek to continue the current August 20th trial date any further, the government committed to producing draft exhibit and witness lists 10 days in advance of the motions and line deadline. This, the parties recognized, was necessary so that the defendants could intelligently file motions tailored to the true evidentiary issues at trial. But once the government filed the third superseding, it behaved as if the August 20th trial date was automatically off calendar and all dates keyed to it vacated. The initial June 19th witness exhibit list disclosure deadline keyed to the June 29th motions date came and went. After agreeing over email to move the motions in limine due date to July 6, a date which triggered a June 26 exhibit trial list disclosure deadline, the government again failed to follow through, and finally, after the court set an August 13th motion in limine date, Mr. Banks' defense counsel reached out in an attempt to confirm the government's intentions to comply with an exhibit and witness disclosure deadline, to set a motion in limine schedule, and to find time to meet and confer example K. As of the date of this filing, the government has failed to meaningfully respond. It remains unclear whether it will provide a draft exhibit and witness list by tomorrow, July 11th, whether it will meet and confer with what key evidence was only discovered very late in the day despite its exercise of reasonable investigative diligence. It does not do so. The government contends, to the extent defendants believe the investigation could have proceeded faster, defendants' own conduct significantly contributed to the investigation's complexity. Government opposition at 14. It lists various ways that Mr. Banks has allegedly attempted to evade arrest or conviction, including by using coded language, instructing others to delete text, attempting to intimidate witnesses, and even by attempting to fly to Dubai the day of his arrest. But what does a flight to Dubai nearly 2 years ago have to do with the last-minute timing of the third superseding indictment, or with the government's delays in producing discovery in its possession? The same question remains unanswered as to the use of coded language, which the government has always claimed to decipher with the help of its longtime cooperators. The instruction to delete text, which were clearly not followed, or alleged attempts to intimidate witnesses. What coded language, for example, was difficult to understand up until last month when the government brought sweeping new charges. Unless the government can tie any of these allegations to its delay, they are immaterial distractions. None of the government's vague excuses stand up to scrutiny. On the contrary, the timing of the government's decisions here were used to gain tactical advantage. It took Chicago off the table as proposed 404B evidence in order to defeat Mr. Wilson's severance motion. Mr. Banks was also induced to put down his pencil as to that issue, so to speak. The government then reintroduced it at the last moment when Mr. Banks had been deprived of the ability to prepare his defense regarding that very complex and circumstantial case in the interim. Now let me say this, y'all. Throughout this time, we have told y'all that a lot of things that the attorneys on the OTF side just wasn't making sense, and we know that the feds play games. And that's exactly what they're doing here. However, one thing I could say is I agree with the attorneys on this one. They know that the feds are playing games, and they are very smart about the games that the feds play. But they're calling them all out. But the only question I have is this. We know that they're games, and if you ever been through the system, unfortunately, you know that these are the games that they play. The last minute games, the introducing new charges and new evidence that they have at the last minute, right before trial. They do this on the average person all the time. However, Durk got a little money and he has attorneys that are actually going to ride for him. And that's exactly what they're doing. These are the games that they play. However, my only question is, even though that they're pointing it out, clearly they are being allowed to do it. So the question here is why? If we know that it doesn't make sense and their attorneys is starting to point it out, who is allowing them and why? And how can we expect the same judge that allowed it to overturn it if they should have never even allowed it in the first place? So I don't know. I'm not sure how it works. This is just my mind going as I read this. One thing I could say, his attorneys made a lot of points. This is probably the first time we saying this, but he did. But like I said, we know that these are the type of games that the feds play. But the fact that they're catching it and exposing it ahead of time, let's see what that means for trial, man. Y'all jump in the comments. Let me know what y'all think about this. Don't forget to like, comment, share, and subscribe. Hit that bell so you're notified every time we drop new content. And remember, as long as you keep on watching, I'm going to keep on dropping. I'm out. Are you tired of a bunch of social media gurus promising you results with their course, but all they do is take a bunch of information off YouTube and Google, then sell it to you? Well, look no further. Our YouTube Tips and Tricks Masterclass course comes equipped with SEO tips and tricks, along with methods we use to growth hack our YouTube channel. It also includes step-by-step ways to publish your video before uploading to guarantee a great SEO score, therefore your videos can rank and be shown to a bigger audience. Views and subscribers don't come by luck, and just how YouTube have an algorithm, you should have one as well that can guarantee you results. We're doing websites and softwares we personally use to generate money creating Faces YouTube channels. If you also would like to skip the process and just buy other pre-built accounts, whether it's Instagram, YouTube, or Facebook, we also threw that in there for you too. We went through trial and error, so you don't have to. Click the link in the description or the comments and get started today.